So for the next few weeks, we'll be discussing the upcoming retrial evidentiary hearing for convicted killer Alec Murdaugh. Now, this is a story that has been dominating headlines, not just in South Carolina, but across the country ever since Murdaugh was convicted, and then those convictions thrown in jeopardy by allegations of jury tampering. We are pleased today to be joined by one of my favorite lawyers in South Carolina. You do personal law, criminal, personal injury. Lauren Taylor from Lauren Taylor Law, thank you for being with us today.
Thank you for having me, Will.
And it's not just a one-time thing. You're going to be covering this over the next couple of weeks as this thing unfolds here in Richland County. Lauren, before we get into this, tell us a little bit about you, about your background in law. You've been practicing for over a dozen years, right?
Yeah. So I'm a South Carolina girl. I actually went to the University of South Carolina, got my JD from Charlotte School of Law, and I started practicing actually in criminal defense when I started. I got on the 608 list, helped out a lot of indigent folks, and really honed my trial skills there. And then family law was, something that was in abundance at the time. So I kind of naturally progressed a little bit from criminal into family law. And now we kind of do it all. And we're statewide. We have offices in both Greenville and Daniel Island.
Very nice. All over the state.
Yeah.
Love it. Well, thank you for taking the time with us. And you have not weighed in publicly, interview-wise, on the Murdaugh stuff. And I know we're going to focus on the case law, but this is your first Murdaugh interview, so.
It's my first Murdaugh interview. I'm very excited to be here.
But you followed it, and you know everybody involved.
I have, just like every other human on the planet, it seems like, has been paying attention to this case over the last few years. So I've definitely been, as a bystander, keeping up on everything. As a lawyer and someone who's in this profession and has had to, deal and bear with the brunt of what this has done to our profession, as well as, what the state is dealing with as far as trying to actually prosecute. It's been interesting to watch it develop, and I think it's far from over, unfortunately.
So how are we looking as a state? How's our justice system looking? You mentioned that what it's done to the system. That's a good point.
Honestly, it's not great, and it's not getting any better. I think Justice Toll is really going to be kind of a beacon in the next few days, or not few days, but when the hearing takes place later in January, and she's going to have to put some faith back into the judicial system so that people can trust and understand this process. And I think that's what really is sparking my interest this time, is this has never happened before. The allegations that Alec Murdaugh's defense is making and the, arguments that the state is putting forth, these are novel issues, and how our state decides to handle it, I think the eyes of the world are going to be on us, honestly.
Well, let's dive into them, because you're absolutely right. This is uncharted territory for case law here, certainly in South Carolina. And let's just dive into this motion for a new trial. Obviously, it's based on allegations that the clerk of court in Colleton County, Becky Hill, tampered with the jury that convicted Murdaugh back on March the 2nd of 2023, last year. But the prosecution has made an argument, and I wanted to put their main idea out there and let you think about that. And I wanted to quote, this is from a pretrial briefing that was submitted just yesterday as we air this, January 3rd, 2024. And I quote, "Not a single juror who actually deliberated on the case indicated that their deliberations or verdict was in any way affected by the improper contact alleged." Right. That's the state's argument, that this didn't have any bearing on the verdict. Now, the defense, however, is arguing a different standard. They're saying, and I quote, that if Mr. Murdaugh proves Hill engaged in surreptitious advocacy on the merits during the trial, there's nothing left for the state to rebut. They're basically saying, even if she had contact, whether it impacted the jury or not, it doesn't matter, just the contact, new trial. Where do you come down on that?
Well, I think that both the state and the defense are referencing Green in that, and that was a case where the bailiff had, which would be a court officer, not to the level of the clerk of court, but they had a communication with the juror, and I believe the juror inquired as to what the procedure would be if the jury was hung or if they could not come to a verdict during that timeline of that evening, I believe it was.
Process question.
Right, a process question. And so he answered and said, I believe that the judge would issue an Allen charge and then would ask if the jury could remain a little bit later to continue to deliberate. So the court ruled there that that was harmless, right? The word harmless is going to be really important when we start getting into analyzing these cases, because like I said, this has never happened before. We've had a bailiff that has had contact with a juror, but there's a difference in asking, where's the restroom or what time is lunch versus do you think I should listen to this person's testimony or should I find this person credible? And that is where we're really going to get into the nitty-gritty about what was harmless and what wasn't and what these jurors are going to testify to. There's a lot of allegations in the in the defense's brief where there were separate conversations a lot of times, that there was one juror in particular that had private conversations. So those are things that, absent a video camera that's recording all of these, how are we going to get to the bottom of what is harmless contact and what isn't?
It could be one person's word versus another.
Right. And I think the state wants to argue that this is Alec Murdaugh's burden to prove not only was there contact, but the contact then rose to a level of bias in that juror, which, essentially means that juror might not have voted the way they voted had the contact not occurred. So the defense is saying we don't have to prove bias. That's not what we're here to do. The contact happened. She was the clerk of court. It was inappropriate. Let's start.
That's
go.
the ball game.
Yeah, do not pass go. Let's start again. They're saying, no, this doesn't have to be that way. But the state has a higher burden here. And I think it's really important to balance the need for people to be jurors. Mm-hmm. It's not fun. You lose 6 weeks of your life, you lose your job, you lose work, not your job, hopefully no one loses their job for that, but it takes a huge chunk out of your life. So we don't want to discourage people from doing this civil duty. And these jurors aren't on trial. They're not, accused of any crimes and they're not victims of anything. So we're taking more of their time and their life by bringing them into these evidentiary hearings. So there's definitely a public interest in trying to protect jurors and their anonymity and the reasons why they voted the way they did and didn't. But it has to be balanced with the defendant's right for a fair trial. And was his due process violated here? And that's what Judge Toll is going to have to answer.
We could even argue that in a case like the Murdaugh, involving the Murdaugh empire, which was so powerful in that part of the state for so long, that need to protect those jurors is probably even higher based on the institutional power.
Absolutely. And I mean, I've tried several cases. In fact, one I tried in Greenwood County where there was an issue with a juror being compromised and we needed to get an alternate in. And during the voir dire, when the judge was questioning the juror about that contact, the juror relayed that, she was scared that these people could find out where she lived and where she worked and, that was, certainly not harmless contact, but it wasn't contact made by any sort of state official. It was an outside source. So I can't imagine the fear that these people, especially the ones that opted to remain anonymous, what they might be going through as this is all dredged back up again.
Let me ask you this question. You were talking about some of the case law that is going to be referenced. Obviously, both the state and the defense, they differ in the standards that they're asserting, but the case law that they're citing, some of the same cases. But you mentioned there's no case law that directly addresses the specific situation we've got now. How much of this decision about Alec Murdaugh receiving a new trial or not, how much of it do you think is going to be based on case law? How much of it do you think is going to be based on the judgment of former Chief Justice Toll?
That's a really great question. Case law, as we saw with Roe v. Wade in the last couple of years, while it's precedent and is typically held to, there's room there for things to change, for a judge to interpret something different. I think the fact that she is the former Chief Justice of the Supreme Court gives her a little bit more insight into whatever ruling she may issue, how that's going to be looked at on appeal, and who the current justices are that are going to be hearing that appeal and what they might think about certain things. Because, whatever she rules, she could still have another, they could still appeal that. So there's a lot of issues here with that. I think she's going to look at case law, but I think she's also, the testimony that's going to be coming out during these 4 days is going to be paramount as far as, the veracity and the truthfulness of Ms. Hill. There are some things that she is the only person that can attest to. And also Judge Newman, I believe, is probably going to have some information that is going to be important for her decision. So it's going to be a mix, with there not being anything on point as far as how to handle this when it is a clerk of court. It's going to be what she feels. And it really doesn't, it's not a clean feeling right now. I think everyone's feeling just a little icky with the feelings and the information that has been released about Ms. Hill in the last couple weeks. So, we're not supposed to consider that, or the justice is not supposed to consider all of these outlying factors, but when you look at it as a whole, it does undoubtedly go to her credibility. I think everyone can agree that it's relevant. We'll see what Justice Stoll thinks.
You're right. In its initial brief, the state of South Carolina argued that Hill was a maligned public servant, that someone who had done her job well. They're not arguing that anymore. It's been a rough few months for Becky Hill, the clerk of court there. She's been accused of multiple ethics violations. She's embroiled in a criminal investigation involving her son, who allegedly wiretapped an official down in Colleton County trying to keep tabs on these investigations into his mother. Also, the book, she's acknowledged plagiarizing portions of her book, and just the book itself, the fact that this was written, some of the discrepancies in that volume. But let me ask you about this. We're talking about Becky Hill and her credibility or lack thereof. How central is that to the state emerging from this process with a win?
Well, I mean, I think one of the poignant parts of the defense's motion was that there is no one else that can, argue against what an alleged juror is claiming other than Ms. Hill. So for her, if she chooses to assert her Fifth Amendment right and does not answer any questions specific to that, I think that's pretty indicative of an answer in and of itself, of refusal to answer.
Well, walk us through that. Can she do that?
Of course she can do that. So for anyone that might need a little refresher, your Fifth Amendment is your right against self-incrimination. So if you're being questioned under oath on the stand and they ask you a question and your answer may lead to criminal prosecution, you have the constitutional right to assert your Fifth Amendment privilege. The defense here is arguing that Becky Hill waived that because she submitted an affidavit denying the allegations that were asserted by the defense. So under, the Constitution, everyone has the right of cross-examination. So by submitting that affidavit denying what the allegations were, she has now teed herself up to be cross-examined by the opposing side. If she chooses not to allow cross-examination by asserting her Fifth Amendment right, which now we've got, I believe, 2 or 3 possible criminal charges that could be resulting just from the duties she violated in her office as capacity, not necessarily relating to just the trial. But I think that's going to be really important. But from my standpoint, if I'm thinking through this as a strategy on the defense, I don't think there's a lose to either side. If she invokes her Fifth Amendment, my follow-up question, or at least in the thought of everyone there, is going to be, why can't you answer that question, Ms. Hill? What about your answer would incriminate you? So it's almost the unanswered question that's going to tell us more. It will be interesting to see if she does try to evoke it, though.
Let's assume for the moment you were advising Becky Hill. Obviously, she's got 2 great lawyers in her corner, giving her good advice. But if you were at her table during that hearing and that moment arrives, would you tell her to take the Fifth based on everything you've seen on the case so far?
That's a really good question, and one I haven't put a lot of thought into. I think at this point, there's a difference between the bell might have already been rung, I think.
Because of the affidavit.
Because of the affidavit, and now, honestly, her admitting to the plagiarism, I think is also, that plus the use of the courthouse and those things. I think it's pretty clear with the emails I've read as well that she misaligned her office to some degree. Whether that's enough to be indicted is, up for another discussion. But I would probably advise her, honestly, at this point, just be honest. Let's just lay all the chips on the table. I think more harm can be done from trying to dig this hole deeper. But I don't know everything. There might be things that I don't know that I could, definitely say, oh, wait, we can't tell everything just yet.
That's a key caveat in that question, based on what you know.
It depends, as
we don't
always.
know everything. That's right.
It depends. But I do think, depending on what other stuff is out there that we don't have any idea about, at this point, it's like we're in a sticky situation here. It doesn't look good for the state. It doesn't look good for your office. It doesn't look good for you. I don't know what the remedy is. It's sounding like the remedy is a new trial for Alex Murdaugh, unfortunately.
That's where you're coming down on it at this point.
That's where I'm standing at this point. I will reserve judgment until after the 4-day evidentiary hearing, but I don't see another option with what has been presented so far. I think there's no way you can say that this was harmless contact. And if we've got not just one, we've got multiple jurors and allegations that one juror was removed that might have resulted in a mistrial or hung jury, So it's too many. It's not just one. When there's so many questions, I think in order to put everyone's mind at ease, especially when this entire situation started with an attorney that was very well respected in the state and nobody believing that any of these things could be in the realm of possibilities. I think it would be a cleanse kind of to say, okay, we didn't get this exactly right. It's not everyone's fault.
Sure.
It's someone's fault, but it's not everyone's fault. Because, I mean, we've got to give it to Creighton Waters and all the time and effort that these people have put into this. Trials are exhausting to every core of your being. And so to have to do this again is not what anyone wants, but is it what justice requires? And I think it might be.
Let me ask you this, because you talked about the integrity of the system, and obviously South Carolina's judicial system has come under significant fire in recent years, particularly the influence of lawyer legislators and some of the strings they're able to pull on behalf of their clients. The Murdaugh trial seemed to stand out, though, as a shining example. Judge Clifton Newman, obviously the way he conducted himself during that trial, it seemed to be the outlier, the exception, and an important exception considering it was internationally televised and aired all over the world, Netflix and all of that. Let me ask you this. You said something a moment ago that I wanted to drill into about what the system demands and about what justice demands in this particular instance. No one is really questioning, at the very least, this man's complicity in the death of his wife and younger son. No one is really questioning that, at the very least, he has lied, to the end of the trail of his potential involvement. And the jury clearly reached the point where they didn't believe anything he was saying at that point. He got caught in lies on the stand. Did they not get it right?
I think it's a hard question to answer, and it's one that if you'd asked me before I went to law school, I would have had a different answer. But after going to law school and seeing, there's a reason that the justice system exists, and there's a reason there are parameters put on things. There have been a lot of trial and error through the years, and we've created the system to try to make it as perfect as possible. Is it perfect? Absolutely not. And unfortunately, whether someone is guilty or innocent is irrelevant to whether their due process was honored and whether they were, afforded the rights they're entitled to. So, when we talk about murderers or family annihilators, as Creighton Waters coined, it doesn't feel good to say, shucks, we got to do this again because it's the right way to do it. That doesn't feel good. It's not easy. It's not what anyone wants, but it's the right thing to do if, Justice Toll decides that that's what's necessary. And I don't see how, in a situation like this, with someone that has, put their hand on a Bible, sworn to take an oath of office like the clerk of court does, she was very aware of what her duties were during this trial and very aware of what was not allowed of her. So that being the office that she holds and it being a publicly elected office, I think it just levels it up. It's different. The circumstances are different, just like the defense states that there is nothing that can even be paramount to this. Like the closest the state can find is a bailiff that was asked about how long are we going to be here. That is not the same. It's not.
You raised a point when we spoke earlier. We were talking about some of and you mentioned just a moment ago Becky Hill's responsibilities and where she may have overstepped them. Clearly, even in the state's motion, they've got a little spreadsheet where several jurors are talking about how she did mention body language, things of that nature. But you also pointed out in the transcript, Judge Newman expressing displeasure that Hill had questioned a juror outside of his presence and not brought the matter to him. Yes. Are these the kind of things you're talking about that go out of that?
So, yeah, and I mean, this is not to say by any means that anyone did anything wrong. When you're going through 6 weeks and we're all humans, we're all tired, our brains are, cranky and just trying to make sense of everything, things are going to slip up. There's going to be harmless errors.
Sure.
The harmless being the important word there. But when I was reading that transcript, he literally said she questioned a juror without me. That is improper. It is. And now he cured it, but he believed he cured it by questioning the juror, separately and asking for more information. The whole Facebook thing is really confusing to me. I'm not sure metadata-wise what could be proven as far as, who actually was Tim
Yeah, this is the egg juror, the juror who was
I believe
removed.
it was Timothy Jones or Tim Jones or something, whether he goes by Timothy or Tim, and whether he posted something, deleted it, and then posted an apology or not. But it did lead to the excusal of that juror. So I think that is an area, and I think Judge Newman knew it was an area when it happened. The issue the state brought up was, why didn't Jim Griffin and Dick Harpootlian bring it up then? Well, you don't know. At that point, you're dancing around a murder trial. You don't know. You might have 3 other jurors on there that, might be better or worse. You don't know what you don't know at that point. And so it's kind of hard to make a decision like that when maybe they wanted her off. Maybe she was one that was going to vote guilty. They don't. It's a strategy thing that is evolving minute by minute, second by second as the trial progresses, and having to decide whether you're going to preserve objections for an appeal. These are, like I said, it's 10,000 decisions when you're in trial mode that you have to make, and if you miss one, it could be a big deal.
And obviously, the appeal, I think it's important to remind our audience, is completely separate from this. This is a bid. This is simply a hearing on whether Alec Murdaugh will get a new trial. His appeal is on hold while we decide this. He's still got some interesting admissibility arguments to be made on his appeal.
Yes. So just to kind of break it down for anyone that might be a little confused about the process. So after the guilty verdict was rendered, Alex was sentenced. He had a time frame to file his appeal. He did do that timely. The law states that if you have a motion for a new trial and the appeal is already pending, you must ask for leave from the Court of Appeals in order for them to hear and have an evidentiary hearing, which the state was asking to be denied. They've obviously already granted and set the evidentiary hearing. So that is the process with that. Now, when and if, I guess it's an if, like I said, I won't speak too soon. If there is a new trial, that is going to be something that is going to be frustrating for journalists, attorneys, the viewer, the everyday citizen, everyone, because what we saw in the first trial is likely not going to be what we see in the second. So I had several cases when I was first starting where I actually tried the same case twice or sometimes 3 times. And every time as a defendant that you are retrying a case, the prosecution has a chance to essentially poke and go fill those holes that you were able to poke in your initial trial. So I think in the first trial, the strongest thing that Alec really had going for him was no one could believe that he would kill his wife and son. The strongest thing that the state had going for him was the video evidence. So knowing that now and being able to go back in and plug some stuff up, whether it's the state, filling some holes that maybe they got back on a juror questionnaire that they didn't particularly want this question answered or they needed more about this, you're going to see a different strategy, though. I don't know if we'll see Alec Murdaugh take the stand.
I was going to ask you
I don't know. We'll see. It's, we can get into a whole personality assessment on, that later, but that might be something that's different. The admissibility of evidence, something I think the jury really struggled with, and because I struggled with it, and I deal with this type of evidence all the time, was the car tracking evidence. And when the acceleration went up and how fast he was going between certain points, to me, that was very relevant. It showed, an urgency in the situation versus just casually driving back from your mother's house. So they need to figure out how to make that more easily explainable to the jurors. They're bored. They're sitting there for 6 weeks. God, hope it's not that long this time. But they need visuals. Like they need to see it and be told and then be told again. And I think that's the part that's going to be hard. And if they don't have Alec on the stand, the state has to connect all those dots. They can't rely on a jury that maybe believes him or maybe doesn't. So I think that was kind of what a lot of jurors indicated sealed their decision in the first trial was his testimony. So if we remove that, the state has a hole to fill that they've got to put some questions or answer some questions.
Amazing that we're talking about strategy for a second potential trial on this. I mean, just unbelievable. Lauren, thank you so much for coming in and sharing your thoughts on this. Before we go, I wanted to ask you one other thing. For the folks who are just following this evidentiary hearing, who are coming into this, wanting to know what they should be looking for as this hearing takes place. Obviously, we've got a status conference scheduled for January 16th. That's going to be in public. Jean Toll, to her credit, is putting all this on the record, and in fact, uploading all the documents online so everyone can read them. But let me ask you this: as we look to this hearing, I don't know how long it'll be, 2 days, 3 days, we'll see. What's the key determiner that people need to be focused on as they're watching the back and forth between the lawyers, as they're watching Justice Toll questioning Obviously, not all of this we're going to see because some of the jurors are going to be questioned in private.
Right.
How are we going to be able to follow this and look for some of these tea leaves for where she's going?
Honestly, it's going to be interesting to see how it comes out, because not every witness, there's something called in camera, which essentially means in the privacy of the court reporter, the judge, and the witness, and attorneys may be allowed to ask questions. But in this hearing, the judge can also completely dictate the hearing. She can say, I'm going to ask all the questions. I don't want to hear from either side. It's going to be interesting to see how she decides to, run the hearing. I think you're going to get a lot of razzle-dazzle from both sides, probably. I would really try to focus on the testimony and what is actually being said, particularly from Judge Newman, and particularly if Becky Hill testifies. I have a feeling we won't hear the jurors. I think they're going to keep those in camera. But the testimony and how Justice Toll is receiving it. Her facial expressions can sometimes tell a lot.
She's got a poker face on her, doesn't she?
Yeah, she's pretty good. She's pretty good, but we'll see.
And the state's decision to put Justice Toll in charge of handling this, your thoughts on Chief Justice Beatty's decision to appoint her?
I think it was fabulous. We have a lot of, despite having some drama in our judicial system, we have a lot of amazing judges. Judge Newman is one of them. I think the way he handled that trial, especially so soon after such a personal loss, speaks volumes to his ability, not only as a professional, but as an amazing jurist and a human being. It's going to be interesting to see how it plays out. That part is still a little in the air.
Well, we are beyond thrilled that you're going to be part of this. Thank you so much, not only for today, but for being willing to come on again in the future as this thing moves forward. And we got those director's chairs. We're going to put them on the lawn outside the Richland County Courthouse. Hope you'll be willing to be on that panel and maybe even help us talk to some of the other folks that are going to be weighing in on this. But Lauren Taylor of Lauren Taylor Law, offices all across South Carolina, thank you so much for sharing your wisdom with us on this, and can't wait to get you back in here.
Can't wait. We'll see what happens.